court must and all not applicable here. They say in paragraph 45, this is the strongest part of the case. In this case, the state submits that due to the fact that the accused survived, that he planned to possess the two firearms, 9mm pistol and semi-automatic rifle. He emptied the 9mm by firing 15 shots, followed by 7 shots from a rifle. That there was a crowd of 20,000 people at the stadium, including supporters, medical personnel, police officers, security guards, coupled with the fact that there's a very condensed community designed right around the stadium, of facts that places the accused in the sentence category between 7 and 15 years imprisonment. They then asked for 10 years imprisonment, and then finally also they referred to the Zim decision to advise for the client. And they say, lastly, the accused is treated and perceived with such contempt, took the citizens of South Africa for fools by trying to convince all that he fired a toy gun, blamed everyone except himself for his actions, confused the law with politics, practiced all intimidating tactics by hiding behind crowds, dragged everyone to be participants in his show. The show is over. This court must send out a strong message to other would-be offenders who fire shots among crowds and endangering the lives of others, that if they commit a crime, they must do the time. And that's the conclusion there. Then, Your Worship, as I already said, they filed the supplementary heads of argument last Thursday, and there's a lot of, with respect to repetition, Your Worship. You see, the introduction is very similar. They highlight the charges that he faces. They concede in paragraph 4, and this is where they go against their previous heads, that the minimum sentence legislation does not apply because they have not been warned accordingly. But they ask the court to impose a custodial sentence, and they do the aggravating features of the case, and they repeat everything that they said in the previous heads. There's nothing with respect to new, so I don't know what the supplementary about this was. With our heads of argument and to respond to the heads of argument. Involved a public leader who planned to discharge live rounds from two firearms before 20,000 people as a rehearsed act of spectacle. And once again, Your Worship, I highlight, they tell you all along, treat him like a normal person, but they keep highlighting with respect that he's the leader of a political organization and you must punish him accordingly. So it's self-defeating with respect. They then also, in paragraph 10, they have a heading beneath it, 2 firearms, 22 live rounds before 20,000 people within a community. And they refer to the firearms being a 9mm handgun, Narinka SPA 249-14, 5.65 by 45mm, Remington semi-automatic assault rifle. But Your Worship, what they failed to record here, or even consider, they gave that back. So if they believe that an offence had been committed, Your Worship, and it was so heinous and it's a prohibited item, I don't understand the sense of having returned it to its lawful owner, but that they don't have any regard to. And they say that such a firearm, in paragraph 11, retains lethal kinetic energy on descent. The potential for mass casualties was real, foreseeable, and scientifically established, but we have the objective fact, Your Worship. And they say that it's pure fortune, that nobody was injured and there was no damage whatsoever, Your Worship, which is a factor that this court took into account in the judgment and ought to take into account on the sentence. It's one of the most important factors we're taking into account. And that's what they say in 12, Your Worship, that no one was killed or seriously injured. It was a matter of fortune, not mitigation. And then, Your Worship, in 15, they say that this conduct is a harm to the values of constitutional democracy itself. And in 16, again, they say the court is therefore called upon not only to punish the accused for his individual conduct, but to vindicate the constitutional principle that public office and political prominence do not confer immunity from criminal sanction, which is the point that I'm making repetitively because they seem to go between those two approaches with respect to it. They then also referred to the decision of Hewitt as did we, and then they claimed that the accused not only had an absence of remorse but also insight and accountability, and that he had maintained throughout and continues to maintain that he committed no offence despite being convicted after full trial on overwhelming evidence, which is the issue that Your Worship dealt with on record and recorded that it was his right. And then they say that he described these proceedings as an abuse of the NPA resources, an incompetent prosecution attributed the undisputed discharge of 22 live rounds. But in 20 they say that firstly and most significantly, Ms. Thompson conceded under cross-examination that she could not find a single case in the literature where a non-custodial sentence had been imposed for the unlawful possession of a semi-automatic firearm. This concession is remarkable. It speaks not to the uniqueness of a lenient outcome, but to the settled judicial view that such offences call for custodial sentences, a view Parliament endorsed through the enhanced penal jurisdiction in the FCA. Now that cannot, with respect, be correct. We handed, my learned friend wasn't aware of it, which I do concede, the more recent decision of the Eastern Cape, Your Worship, where there was possession of an unlawful firearm. It was an illegal homemade firearm, and there was no custodial sentence imposed, and we dispute that such a concession was even made, Your Worship. We don't find it in the record. I know that sometimes the records aren't 100% accurate, but my learned friend can elaborate on that, because that appears from his supplementary that's filed last Thursday. Then they deal with the issue of Mr. Thompson's recommendation of premise no characterization of the possession as brief, benign, and celebratory. On the brevity, they say the brief duration of possession is relevant only where possession is accidental or fortuitous. They say here it was pre-planned and deliberate. Benignity, 22 live rounds. They said the ballistic risk was extreme. Celebratory purpose, they said the law does not distinguish between a reckless act done for enjoyment and one done for malice in assessing objective dangerousness. The rest we say is for repetition, but then they say, Your Worship, in 22. Fourthly, Ms. Thompson's assessment of the risk of recidivism was superficial. She relied on the mere passage of time since the offence. She did not grapple with the fact that the accused who leads a political party that has staged multiple large-scale events since 2018 has demonstrated no acknowledgement that his conduct on 28 July 2008 was dangerous or unlawful. The absence of reoffending in the interim is not on its own indicate that no such risk exists. Now, recidivism is defined as the tendency of a convicted criminal to reoffend, relapse, or go back to its way. And that's the clearest indication is looking back on time to say that did such a thing reoccur. So we submit that Ms. Thompson is accurate in that regard, and they, with respect, seem to have misinterpreted the term recidivism, and it wasn't superficial, because we look back in time, we say, were any other offences committed in that time in the past 8 years? And the answer is no, because the clean SAPS 69 was handed in, so it doesn't appear that she's inaccurate in that regard. They then respond to our submissions, Your Worship, on sentence, and they dispute that celebratory discharge cases are distinguishable. They say that you do have outcomes where there are no thing, but they say they're distinguishable. And then, as dealt with in the previous head, Your Worship, they say the stories there was no premeditation. In Munsani, the accused intoxicated police officer fired at a canoeist in a moment of madness. For June was a crime of passion. Bader was a firearm and reckless endangerment, not discharge. So they say they're all different. And we say, yes, Your Worship, but at the same time, and the most glaring fact, Your Worship, is they could not find one case in our whole history of all our cases, Your Worship, of
shots being fired at a funeral or a celebration that resulted in a prosecution. And that's a fact that stands out on its own, Richard. And then they said the no harm, no injury argument misrepresents the nature and gravity of the charges. And they say no one was injured, no property was damaged. The state acknowledges this, and that this they describe as being purely fortuitous. But what they don't mention here, Your Worship, and Your Worship went through the trial, so Your Worship knows, there was not one eyewitness that came to testify before this honourable court. The state was prominent leaders. If anybody was in fear, out of all those 20,000 people that they now rely upon, it was incumbent upon them, either in the trial, Your Worship, or even in aggravation of sentence, to lead that evidence, but they didn't. Even the SAPS who were on the stage, Your Worship, were not called by them to testify, even in aggravation of sentence, Your Worship. Not even the Gearhouse people, Your Worship, said that they feared or worried for their lives or ran away. No single person stood before this honourable court saying, I was afraid of being injured. I saw this as reckless, callous, and dangerous, which is something that they ought to have led if they wanted to prove that there were aggravating circumstances. They then, Your Worship, tried to fall back on their previous heads of arguments and say even where the minimum sentencing regime does not apply to case law, establishes a clear sentencing range for unlawful possession and discharge of semi-automatic firearms. They then quote our constitutional cases that we quote, so the principle is clear from that from the case of Makmanyani, Your Worship, and BFF versus the Speaker. Then they turn to the personal circumstances of the accused, and they say it's a double-edged factor. It may be often in mitigation of personal circumstances that is a public leader and member of parliament, but they say this is the most significant aggravating feature of the case. So now, Your Worship, they argue, treat him like any normal human being. At the same time, they say, no, this is the single most aggravating factor of the case. The two are mutually exclusive with respect, Your Worship. They acknowledge, Your Worship, in F, that all 5 counts arose from a single continuing incident, but they say the remaining counts serve to aggravate the primary count, not merely to establish its context. And then, in their concluding submissions, Your Worship, they go back with respect to the imperative of equality before the law. So you asked on the one hand to make an example of this accused because he was the leader, current leader of a political party. Then they tell you no. There's an imperative. You must make us all equal before the law. And they say there themselves, they say sentence that treats this case as an exception to well-established sentencing norms would itself be an act of unconstitutional discrimination against the poor in favor of those with means and the powerful. Now what we're saying, Worship, is they seem to imply that to impose a fine would be unconstitutional. It's not the case, Worship. You can impose a fine. It's recognized even in the post-constitutional era that a fine is a punishment, as is a suspended sentence, as are other forms of punishment. They are recognized. Then they ask for the imperative of proportionality and the imperative of deterrence. And then they repeat themselves, Your Worship, in paragraph 35 yet again, where they say, and I'm going to quote because you'll see just how many times they've said this, the accused has treated these proceedings with contempt. This is from the previous head, Your Worship. He fabricated a false account of a toy gun that was comprehensively dismantled by the overwhelming evidence at trial. He refused to cooperate with investigators. He characterized this prosecution as an abuse of the NPA. He blamed VIP protectors, the Holy Spirit, and everyone except himself. The show is over. The court must now ensure that justice is done, not because the accused is prominent, but because the rule of law requires that every person who commits a serious offense faces a serious consequence. And they therefore go back to the zin as they did in the previous heads and ask Your Worship to impose. Now, Your Worship, what's lacking from all of this, and which leads into the allegation by the accused that this is an abuse of the NPA, is the objective fact, Your Worship, that we as a team and the state as a team, and I believe Your Worship too, were unable to find any case of any single individual who's ever been prosecuted for firing shots at a funeral or at an event or a celebration, despite all of us having seen that regularly on our TV, on the news, etc., etc. We therefore say, Your Worship, that a more appropriate sentence, taking everything into account, would be to take all the charges together that arise from one incident and to impose a non-custodial sentence, which may incorporate a fine and a suspended sentence and any other order, but to incarcerate the accused, we say would be startlingly disproportionate to the offences here, Your Worship. Thank you, Your Worship.
Thank you.
I now have another right of reply. My little friend's in a difficult position because his heads have been alluded to, but I'm sure he's going to add to them as well and deal with.
Yes, and then obviously you may reply
As Your Worship.
if
Yes.
something.
I think
if
Mr.
there's-
Guy told you will do the reply, Your Worship.
Oh.
With your leave. Thank you.
Advocate Oleg, there's just one aspect that I want to ask since you've raised it
Yes.
now, and I've read it in the heads and heard in the evidence of Ms. Thompson. And that is the part of the firearm being handed back before the court passed judgment. That is not within my knowledge. So,
It is, Your Worship. It's in her report. She testified.
no, it is in a report. I'm saying it's not within my knowledge. I'm hearing it from the defense.
No, Your Worship. Yeah, there was no evidence. No, there was evidence there. She testified to that.
No, I don't
It's in
think
her
you.
report and it's in her testimony. And Your Worship, it's a logical conclusion. My learned friend who was in court and would be aware of it never disputed it once.
Yes. No, look, no, maybe I'm not. I heard her saying so. There's evidence by the defense regarding that. I'm just not sure where it's coming from. You don't have to. I accept it's there. And as you say, it wasn't challenged, but it's not within the knowledge of the court that it was returned before judgment.
No, it is, Your Worship. It's in her report. She was led on it. No, I was also astounded by it, so you'll find I've given Your Worship the page reference.
No,
And the
I've
report
seen it.
reference.
I know it's there. I do confirm it is contained in her report
Had
and
it-
in her evidence.
Had it not been the case, Your Worship, my learned friend was obliged to challenge on it and he didn't. So it's an objective fact and it's evidence that was led before this honourable court. I don't know why there's a noise, Your Worship, and I don't align myself with it.
No, it's the
So let me
same.
repeat what I was saying, Your Worship. She testified, as Your Worship knows, it's in her report, and my
Yes.
learned friend was present and never ever cross-examined her on
Yeah.
that aspect. So with respect, in our submissions, a proven piece of evidence before this honourable court.
Look, just I hear you, I agree, and then I saw it in your heads, and that's why I thought I'll ask because I'm not sure what the source of that information is, but it's neither here nor there. As you say, it's on record. I'll hear if the state has any reply to it, but it's not. Thank you. It's so noted. Thank you.
Thank you.
All right, Advocate Caesar, are you ready or?
I think we must get this over and done with here, Your Worship. I'm ready.
I know it's inconvenient. You don't have to move. We do have lady staff here who are requesting a bathroom break, which is 5 minutes. We can return within 5 minutes. Don't want to put anyone on the spot, but
Perfect, Your Worship.
I'll just leave all my stuff right here, so I don't have to carry anything. Don't know who else, but sorry, the public, the gallery. If you do need to go out for facilities or water, etc., just please stick to the time frame so that we are back in time to proceed, because it's a lot who has to go out and back, and then 5 minutes becomes 15. So I know everyone can't manage in 5 minutes, but I'll be right here. Sorry for that. Let us just allow everyone that.
10 minutes, Your Worship.
Okay, so it's now, let me say, should we now just do the tea adjournment and get it over with? Is that fine? Do you want us to do the tea adjournment now? Then I return at exactly 11:15 and then we go right through. Fine. I can't hear. The defense, is that in order? I
Yes,
can't
Your
hear.
Worship. No, we don't have any.
Okay. Court will adjourn until 11:15. Thank you. Oh, if that's the case, then yes, the charge is. Then I'll take it. the file is interfering with the recording at all. We hope not. And then we'll be ready. Please be seated. We'll be ready. Please be seated, Mr. Malema. Okay. All right. You may proceed, Mr. Caesar. Everyone from the defense also ready to proceed? Thank you.
Can you, Worship, just inform everybody again that the cell phones must be switched off or on silent?
The gallery, you heard that? Is our interpreter here? Ms. Mabwa, please. Thank you. Just a minute, sorry. All right, Caesar, I'm ready if you are.
Thank you, Worship. Worship, I don't know how council expect me to impress my bosses if he has done half of my job for me. One thing is certain, I'm not going to pay him 1 cent for that, Your Worship, for doing or attempting to do my work for me.
Please go ahead.
It was when I was at the magistrate's course many years ago. They had this 3D dimension on the board where we each were required to say or what exactly was on that particular 3D dimension. Some saw elephants. I saw a head of a man, an old man. Even some saw a lion, some saw 3 heads. The point that I'm trying to make, Your Worship, is that we're looking at the exact same set of facts with different views relating to that particular fact. That is the court's duty to find which one is the more plausible argument. It's not for me to minimize counsel's argument and vice versa. There's just 2 aspects that I need to rectify right from the beginning. The issue relating to the filing of heads. My heads, I confirm it was filed on the 1st of April. The issue that I need to address is the condemnation issue because I did call Mr. Mkwanazi on the 31st, informing him that my heads are ready. It's ready to be filed. I wasn't in office. I was on the road. And I did not want to send unsigned heads, which he confirmed that there will be no issue. Why counsel raised it like I had to apply for condemnation? To me, that is sufficient. It was filed first thing on the 1st of April when I got back to the office. The second issue that I also relating to the condemnation, I did not read counsel's heads on the 31st. Reason being, as I already explained, I was on the road. I was not in office. I was unable to read it. That's the reason why I contacted the attorney, Mr. Mkwanazi, because I did not have any other person's number. It's my view, a response to the heads of counsel in the supplementary heads. There's no need to apply for condemnation on that aspect. That's a matter for debate. The second issue that I want to address is relating to the firearm that was given back to accused number 2. It was given back to accused number 2 on the day when he was found not guilty. There was a prior agreement between the attorney for accused number 2 via emails that was sent to one another between me and that should accused number 2 be found not guilty, that the firearm would be returned. If he was found guilty, the position would have changed drastically. The issue about the firearm being given back, it's our submission that that is a storm in a teacup. We are fully within our rights. If you read Section 30 of the Criminal Procedure Act, Section 31, which allows us to give the firearm back if there's no need for the firearm to be kept further. If I might read, just to assist counsel, what this particular section says relating to that. Sure. I don't know if it's the lights or what.
I think it's the bright light behind you may cause a glare. I'm not sure.
If you can ask my little colleague, because it's so, I will actually ask counsel to read that particular part for me. You must read Section 30 and then Section 31(1), because I can't see. I don't know if the lights.
Just borrow someone's spectacles. I forget Caesar.
It's time. It's time.
It's time that you go and get spectacles.
Sure.
Oh, he's got
No.
them there. Look.
This you should.
Sorry.
I got the spectacles.
Now we
No, it's
we
much
are in a
better.
spectacle. All right.
much better. Section 30 deals with disposal by a police official of an article after seizure. A police official who seizes any article referred to in Section 20, which we know it's articles which they lawfully entitled to seize from an accused or a suspect or any person who is suspected to have committed a crime, to whom any such article under the provisions of this chapter delivered may, if the article is perishable, with due regard to the interests of the persons concerned, dispose of the article in such a manner as the circumstances may require, or may, if the article is stolen, property or property suspected to be stolen with the consent of the person from whom it was seized, deliver the articles to the person from whom, in the opinion of such police official, such article was stolen, and shall warn such person to hold such article available for the production at any resultant criminal proceedings if required. I'm not going to read the last one, C. I'm going to go to Section 31, subsection 1A, that deals with this particular issue. If no criminal proceedings are instituted in connection with any article referred to in Section 30C, or if it appears that such article is not required at the trial for purposes of evidence or for purposes of any order of court, the article shall be returned to the person whom it was seized, if such person may lawfully possess such article, or if such person may not lawfully possess such article, to the person who may lawfully possess it. We had no need for that firearm anymore after accused number 2 was acquitted. They didn't need to come and apply or bring an application for the court to make such an order. We did not deem it necessary. It was well after within our rights, after consultation with the investigating officer, that such article be returned and that he be warned that such article may be made available maybe at a later stage. That is exactly what happened. It's my submission that this issue about the firearm being returned is a storm in a teacup. because we were perfectly within our right to return it. The investigating officer has retired. If that article went missing in his absence, it would have caused a greater problem. So that's why the decision was taken to give him the article after he was found not guilty. Ms. Thompson's evidence regarding that particular article, she was not cross-examined because that is evidence that she got from the accused or whoever was informing her that that particular article was given back. It's the same storm in a teacup that was made about the laptop where the video evidence was stolen, despite the fact that it was kept on another hard drive. The laptop was a non-event, so we didn't need to focus on that particular issue. The evidence was still there; it was already collected, just as the article prescribes. Since that issue now has been dealt with, and the law allows us to do so, I want to deal with the issue relating to Section 9 of the Constitution because that is where everything starts. It guarantees equally before the law and the right to equal protection and benefit of the law. In the context of criminal offenses, the Constitution obliges the court to protect and promote the rights of every individual, ensuring that no person is above the law. I will get to this particular part in a later stage, just to respond to what counsel was referring to about the double-edged sword relating to the accused being treated equally before the law like anybody else, and the fact that we mentioned that he was a public figure and that he should get a more severe sentence than the normal man on the street. And so far as sentencing is concerned, the court is well aware that courts are obliged to take into account the aim of sentencing, which is retribution, rehabilitation, prevention, and deterrence. The court must consider the personal circumstances of an accused, the seriousness of the offense, and the interest of society. I'm not going to go through my acts page by page, but we have referred to State versus Banda and others.
Sorry, so I follow you. Are you doing a combination of the first and second, or which one are you busy with now?
I'm busy with page 2.
Of the first one.
Yes, it's the first one.
Thank
First.
you. Just so I can follow you. Thank you.
Yes, the accused's personal circumstances was well articulated by the probation officer, Ms. Thompson. I will deal with the flaws of her evidence when I refer to my supplementary heads of argument. It seems that basically she relies on those factors that the accused did not injure somebody, that he possessed a firearm for a short period of time. And then she made a recommendation because he also have a soup kitchen that he is responsible for, that he should get a non-custodial sentence. I want to add to this point, Your Worship, that I also received the matter, the judgment on sentence of Justice Brooks this morning. I am going to go through it, but I will deal with it briefly, just briefly. If the court allows me time to read it properly, I can produce many similar judgments of the same judges in the same division where they differ from opinion, which is within their right to do so. I didn't deem it necessary to hand this particular judgment up by the DJP, the Deputy Judge, now retired Judge President Van Zyl, where he has an opposite view regarding firearms. The matter of, it's an appeal matter, a full bench appeal judgment. The matter of Romeo Jansen, the case number, it's CANR 220/18. I just want to see the date when the judgment was delivered on the 29th of August 2019. This is a full bench matter where he held the exact opposite view of what Justice Brooks held regarding the possession of firearm. And this already outweighed the judgment as counsel has handed up of Mr. Nolan Linzima Ndila, because this is a full bench judgment of the same division. I'm going to give counsel a copy as well, if I may hand it up for the court's benefit. Your worship doesn't even have to be concerned. The fact that that judgment already outweighed this one, which is by a single judge, the court can rest assured, because the Supreme Court of Appeal already dealt with this particular issue relating to firearms. We know that the Supreme Court of Appeal is the highest court, and then the Constitutional Court, the apex court. So the reason why these judgments are relied on by the Supreme Court of Appeal, because of these different judgments from different divisions talking about the same issue, having a total different view. Like I explained earlier, how you can look at the exact same picture and see a different thing. He differs from Judge Brooks, gave a direct imprisonment, quite a substantive one in that Romeo Johnson appeal matter. Your Worship, I want to be upfront that the state is seeking a custodial sentence, and if we can get the maximum sentence of 15 years, counsel correctly said that we do not rely on the Minimum Sentence Act. We do rely on section 121, which refers to the maximum sentence of 15 years. And I'm going to tell the court why we are relying on that particular sentence, or the request to impose at least a 15-year term imprisonment. Your Worship, without being prescriptive, it is correct that the custodial sentence will send out a clear message. Counsel referred earlier about this happen regularly, where people just send fire shots at events, at funerals and so on. I must say, I only saw it on television once, is the one that was highlighted by the deputy mayor, I think, of the Nice Now George municipality. The outcry because of that shows that that should not be tolerated in a civilized society where people's lives are placed in danger for people who are in a celebratory mood firing shots. And in most cases, these people are unqualified to fire such shots. In this instance, accused did not just fire one shot and left it at that, which we can consider to be an accident. He was malice, to say the least. His actions constituted extreme danger to the 20,000 plus people that were present, not even mentioning the community right around Mdansane, which we know it's one of the biggest locations in South Africa. It's condensed, it's densely populated, and especially on a weekend, it is busy in Mdansane. It was by the grace of God that nobody got hurt.
If I think I repeated that, I said this on the 23rd of January. If there is such a response, I'm not going to ask you to be quiet. I'll order you to leave. There won't be a choice. Understood? Please interpret, Ms. Margot. You may watch outside if it's going to cause a delay in or noise. Ms. Margot? Advocate Caesar, you may proceed.
Thank you so much, Your Worship. The accused is a political leader. He's got a huge following. Young people emulate this type of behavior. What he doesn't realize is that he already opened the Pandora's box where he creates the impression that this type of conduct is acceptable. What did Pastor Moore did do? He grabbed the firearm, ran to a school, screamed it was a toy firearm. Deputy Mayor of the Landsler George municipality fired shots, screamed it was a toy firearm. That's the president that he said. That people think they can get away with doing this kind of offense. Courts said to clear this that such barbaric behavior should not be tolerated. Accused a member of parliament, a lawmaker. Yet he's the one that broke the law. If it was anybody else, you would have screamed that that person should go to prison. But now the two foot or the shoes on the other foot is screaming, give me a custodial bail. This council already mentioned what I was about to say in most of these cases. But what I want to read to the court is the case on paragraph 4, on page 4, paragraph 10 of my heads of argument, which is one of State versus Lester. The citation is in my heads of argument. This issue particularly deals with Thompson's evidence and how the court should view such particular evidence. I want to quote, I remain unpersuaded by the submission in counsel's heads of argument that the court should have adopted an opinion of Dr. Sidley that the goal sentence would undermine the treatment in which she would have to submit herself. Present one knows is not a continual place, and the conditions may well be less than ideal for psychotherapy. But then a prison is primarily an institution of punishment, not a cure. As a court of law, was it pains to point the approach of a sentencing officer is not the same as that of a psychiatrist, and if I might add, also a probation officer or a social worker. The sentencing officer takes into account all the recognized aims of safety, including the confusion. The psychiatrist is concerned with the diagnosis of rehabilitation. Psychiatrist is concerned to focus on the well-being of an accused at the expense of the other aims of sentencing, so the interest of the community as a restored process and be produced in all likelihood a warped sentence. Now I went through the Oxford Dictionary to try to understand what this word warped means. It's something twisted, bent, or must have something diverted from its original form. It also refers to a distorted it's a guy that's abnormal. I'm getting going for an idea stuff.
Please do.
I'll keep you now for a while. It refers to a distorted, abnormal, or perverse mental state, or sense of humor, or twisted moral values. If the accused get a non-custodial sentence, but this is basically what a law now would go to. It will tell people that it's okay that if you find yourself, whether it's 1 or 2 or 10 or 15 or 22, it's fine, you just get a fine, non-custodial sentence, because this is what the kind of sentences the courts are imposed. Whereas it's my submission, it's not. All the cases that I've listed in my heads of argument, all the accused got direct imprisonment. Counsel also stated that I referred to the minimum sentence that I don't see the fact of the matter is the point that we were trying to make, that the minimum sentence at the end of our harsh judgment is a pains to explain that court should impose standardized sentences, whether it's minimum over 15 and up, or maximum 15 and down. The sentences should be more or less the same, depending on the facts of that particular case. I did not refer to my past because I want to call attention that you should get it. down to that for certain type of offenses, standardized sentences, whether it's minimum or maximum, should be imposed. That was the intention of the legislature. In State versus Airport, on page 5 in my head. Paragraph 14. I quote, there will undoubtedly still be a gradation of seriousness taken in the unlawful possession of firearms. In this respect, much will turn on the circumstances in which the unlawful possession occurred. There will be cases in which it will be evident that the possession, although unlawful, was relatively noxious, and that the weapon was unlikely to have been kept or used for any nefarious purpose. It refers to a sentence of 15 years imprisonment in such cases is clearly disproportionate and irreconcilable with the constitutionality of the implementation of the prescribed sentence. There will often be an evidential burden on an accused person to give an explanation showing that his possession of an unlicensed firearm was relatively benign. That will be all the more so when the weapon concerns we know these were two firearms that were fired. There was a submission that nobody came to come and testify already. We are to this point already. We had all the evidence, the video evidence, was the silent witness. It gave us everything that we needed to know. No witness would have been able to describe everything that we saw on that video. To rely on the fact that no witness came to complain and so on is neither here or there, or that we did not call any witnesses in aggravation of sentences, either neither or that. The video speaks for itself. They say a picture speaks 1,000 words. This is one of these. I've always had an issue when I see words like obnoxious and so on. I'd like to consult the dictionary to understand what is this person trying to say when he uses words like that. The word in this obnoxious, in this context, is meant not harmful injuries. He describes something safe, inoffensive, or unlikely to cause disapproval. Often refers to remarks, behaviors, or substances that seem harmless, but may not be. Synonyms include harmless, safe, innocent, inoffensive. We know for a fact that this firearm was not fired, both of them were not fired innocently. This accused testified he planned it, and when asked why did you choose a particular direction to fire, he says, don't tell me how to fire a shot. I can fire it even from underneath the stage if I feel to do so. It is not innocent. His intention was clear. He was going to do whatever he wanted to do, regardless of the circumstances and the situation and the danger it might have posed to the people around him. It was on the video, it was clear people were running. He disputed it until the last minute, but the evidence was there, we've seen it. There were 7 people in the direction, 20,000 right around.
Imagine being able to build an app with your name on it, just by thinking about it. Meet Base 44, a complete AI creation platform. Describe what you want and watch it take shape.
As was envisaged by the Malchus, there's indeed been achieving respect of sentencing for the possession of semi-automatic firearms. We know that this one was an assault rifle. Despite it being semi-automatic, its size of the ammunition is dangerous. So the Supreme Court of Appeals referred to the tendency of the court to use, even only as a starting point, historical sentencing patterns as a provisional standard for comparison when deciding whether a prescribed sentence should be regarded as unjust. Again, like I said earlier, it's neither whether it's a minimum sentence that's applicable or maximum sentence, a standardized approach to sentences for certain offenses. I refer to all the judgments that the council assisted me by Kane, Asma, Domfly, Sibanda, Data, Kubo, Lahi, Fatwe, Giorgio, Tao, Mukobo, the judgment that is closer, in my view, to more or less the same similar circumstances, not a firing. I don't have to be misunderstood when counsel reply. It's not a firing of the shots for celebratory purposes and so on. I don't want to be misunderstood. But what I am trying to understand, what I want to point out, these people did not have the firearm for long periods of time. I have referred to it in my cross-examination of Ms. Thompson with the matter of State versus SWAT, where the appellant was convicted on 2 counts of unlawful possession of a semi-automatic firearm. The court confirmed the minimum sentence of 15 years on one of the counts in view of the fact that the appellant reported a denial of possession, which the denial was found to be false, which is the same as this instance. He said he had a firearm, he said it's a toy. He still maintains it's a toy, regardless of the evidence, already overwhelming evidence proving otherwise, that this was indeed a real firearm owned by the owner, which we gave the firearm back to, which was ballistically back to after he was found not guilty and discharged. And furthermore, that no mitigating circumstance in relation to his possession could be inferred. The court held in the SWAT case that there was nothing to place in unlawful possession of the firearm unless alias life and then which motivated the lawmaker to lay down a minimum sentence of 15 years. However, the further count of unlawful possession of a semi-automatic firearm, the appeal against the minimum sentence imposed was upheld and replaced with a sentence of 7 years imprisonment. This gentleman had 2 firearms. Mr. Thompson testified, said, yeah, well, 2 firearms, not taking into consideration, even when it was pointed out to him that the accused fired with 2 different caliber firearms, which he denied that he knew that the one was smaller or bigger, something that was so obvious to see. I don't know firearms well, but you know one is a rifle, the big one, and one is small, it's a heavy gun. In this regard, the court held that the state accepted the appellant's version to the effect that the court usually came across the firearm in the garbage dump and was apprehended the same day. Here, Mr. Thompson was saying that here we didn't know how long did he have it, and all the fact of the matter is a day has got 24 hours in it, and he was apprehended the same day. The appellant's decision to take the firearm into his possession could be regarded as having been made in the spur of the moment. Furthermore, it was held that the appellant did not have the firearm in his possession for a very long before he was apprehended. He didn't have it long, same as was reviewed by Wisconsin, yet this is the sentence the appellant was given. One was 15 years in respect of the one firearm, then on the other firearm, the sentence was reduced to one, correctly, of 7 years in prison. The court held that in the circumstances of the crime was such as to make a sentence of 15 years imprisonment as proportion. That was the one that he did not have for a long time. The other one, we didn't know how long he had the firearm in his possession. What I want to point out in this particular matter is not said whether he fired shots with this particular firearm or not, or whether he used it in the commission of further offenses. My memory serves me correctly, counsel, I probably did point out that matter. It's just I can't remember what exactly was said regarding that particular point. The fact of the matter is that he did not have the firearm for a long time. So the state versus the court of law dealing with a fully automatic firearm. When J expressed reservations about the suggestion in some judgment that the possession of a firearm, unlicensed firearm, should be treated as serious only if the weapon had been used for the commission of the offense. The point that I just raised just before this, it looks like the impression is created that if you have a firearm in your possession, you should commit other serious offenses for you to qualify for a 15-year imprisonment, which is not the intention of the legislature. That's why the Firearms Control Act was enacted, because of the seriousness that the Parliament deemed it necessary, the legislature deemed it necessary to make a specific act for firearms because of the serious nature that it poses. The legislature did that in order to single it out for harsh punishment. You are already guided by the cases in the Supreme Court. You don't need to really consider all the other cases, whereas there's already authority from the Supreme Court of Appeal saying that harsh punishment should be imposed. Both them were led to not like Supreme Court of Appeal upheld the minimum sentence for the possession of semi-automatic firearms. So in cases when accused is convicted of a standalone offense of unlawful possession of a semi-automatic, the courts are taking an increasingly unsympathetic stance towards offenders. And terms of imprisonment with a range of 7 to 10 years imprisonment are commonly imposed. In addition, the accused's personal circumstances, one of the most important factors deciding the appropriate sentence is his explanation as to how the unlawful possession came about. What did he say? He's planned it all along, even the EFF planned this all along, that this is what they're going to do for show, to entertain the crowd, not taking into consideration the consequences it might have caused. And it's no wonder the accused went right to the right side of that stage, firing those rifles, realizing there's only a minimum of 7 people that were standing there. It seems that the judicial sentiment increasingly does not support the view that possession of an unlicensed firearm should be treated as serious only if the weapon has been used in the commission of the offense. And in this case, we know for a fact that he did not, he used it. He was found guilty of all the other alternative counts or the other counts because he has used them. He was charged for that and he was convicted of those offenses. I've already alluded to the fact that there were so many people there and the danger that the accused posed to their community, the supporters. Therefore, the state prays for the maximum sentence of 14 years imprisonment in light of these aggravating circumstances and factors that are already pointed out to the court without being prescriptive before. Now, in respect of the possession, unlawful possession of firearm, they should have actually been charged with possession of at least 22 of those live ammunition, because if the logic dictates if one of those were linked to that firearm, it should have been 7. Logic dictates that the other 6 that went out before them was also live ammunition. In respect of count 3, 4, and 5, the state will submit their fines may be imposed on those sentences and will not impose such type of sentence, and that we say it's because of it's a single event, different counts arising from one single intent, that these sentences may run concurrently. I know counsel said this already when you read I get paragraph 47 on page 30, as I was concluding, that the accused have treated this proceeding with such contempt. He took the citizens of South Africa for fools. When he tried to convince everybody that he fired the toy gun, everybody can see that it's not a toy gun. He blamed everybody for his actions. He confused the law with politics. He practiced all intimidating tactics by hiding behind crowds. Dragged us to be participants in this show. It's time for this court to tell you that this show is over. Court must send out a strong message to other offenders who fire shots amongst crowds and endangering the life of others, that if you do commit the crime, you will do the time. Counsel refers to the supplementary as the repetition of the court. I submit that these authorities are entirely inapplicable to the present sentencing inquiry. It's not applicable if used for the death penalty. We are not seeking the death penalty. Its ratio has no application to the imposition of a proportionate custodial sentence for serious firearms offenses. It doesn't even relate to firearms. It concerns a constitutional crisis involving Parliament, observations about the rule of the court as a stabilizing force support the state's position. Court must uphold the rule of law and the principle of equal treatment. Mr. Swartz was sent to prison. Another gentleman I referred to also was sent to prison. How fair will that be? Will that be a consistent, standardized approach? If a non-custodial sentence, what must Mr. Swartz think when he hears or sees that the accused, because of his standing in society, the fact that he's famous, that he did not get a custodial sentence like the ordinary man on the street? It's my submission that will be really a discrimination against the poor in favor of those powerful. It's a very, it affirms the constitutional value of individual liberty. The state does not seek to ignore that value. It submits that liberty, properly understood, must be balanced against the rights of 20,000 persons whose safety was deliberately imperiled, and against the rights of society to equal and consistent application of the criminal law. Council said that I asked one thing and then I referred to another thing. That's why I specifically said in my head that it was a double-edged sword, and the court must understand it that way. That 7 years is for an ordinary man. Above 7 years and up, it's because of his position and the precedent that he created by doing such. The case of Pretorius was never charged for being in possession of a firearm. He was charged for discharging a firearm in a restaurant of 200 people. He was charged with unlawful possession of ammunition and not possession of firearm. To rely on that issue for the firearm related offense, it's displaced. Because that issue, he was imposed that type of sentence for that discharge in the restaurant. If you multiply, I don't know how my account, that was 100 times more. In this case, Victorious, fired, shot accidentally, and he was imposed a suspended sentence. Contrast with the accused who fired according to him deliberately so, says he can fire anyway if he accused first. Yet this man was a contrary because he knew he was not supposed to do that. In this case, the accused says, I can do this, please don't tell me how to do that. So the 200 people that were multiplied that by 100, then we'll get to 20,000 people. That's how serious this was. Was the Pretorius 200? He just fired 20,000 people plus excluding the community around. points just to conclude. The court must consider the degree of premeditation, the lack of remorse, the inadequacy of Ms. Thompson's evidence. She spent 5 hours assessing the accused, and I'm not talking about 5 consecutive hours that you can at least get an idea who the person is she's dealing with. She speaks about an hour and a half here, an hour there, and 2 hours there, on different dates, different times. She was just basically there to do her job, just to compile a report for the purpose of these proceedings, but did not compile it to assist this court to come to the correct decision. She was biased in her assessment. Basically, she was employed by the accused to come and bring that report for him. She was paid for it. His absence of remorse, insight, and accountability. Until today, he still doesn't see what he did, what danger it posed, and what the consequences could have been. His position as a public leader and a role model to the young and to society, that there is a lawmaker breaking the law. In fact, 2 firearms were used and live munitions were fired, not once, like in Oslo Pretoria, not twice, but multiple times. The degree of premeditation involved and his deliberate conduct puts him in the category of 7 to 15 years. The court imposed a custodial sentence. It will satisfy the principles as set out in State versus and the court will do its constitutional mandate of equal treatment before the law and will serve the legitimate and pressing interest of a society that has the right to expect that its leaders and lawmakers be subjected and to obey the same law that they are elected to uphold. That's my submission, and that's going to be asked for.
Thank you, Advocate Caesar. I will be with you now. I just want to get the charge sheet and endorse. I'll be with you now, Advocate Ndrupa-Tobe. Thank you.
Just one issue that I also need to put on record that Mr. Snyman, the state conceded that it did not prove its case beyond reasonable doubt, that it was unable to show in the video or see the video that it was Mr. Snyman that gave the firearm to Mr. Malema. That part was inconclusive, and that's why the reason why Mr. Snyman was acquitted.
And the
You
floor
also
is
think
yours.
I have
Thank
5
you.
points to apply to.
Yes.
The first one is the firearm issue. It is an important issue, although my learned friend tries to make light of it, because it's all regulated by statute. First, your leadership wanted to know what the source of the evidence is. The first part is page 21 of the report by Ms. Thompson, at paragraph 50.4, where she says, it appears that the accused received the rifle ready to shoot from someone authorized to possess and handle it, most likely from the Tactical Security Services, who provided security services at the celebration event. However, no individual was convicted of supplying or transferring the firearm to the accused. And this is the crucial part. And the rifle that was shown in court was returned to Tactical Security Services before judgment was delivered in this trial. That's the first part of the source. Then go to the transcript of the evidence of Ms. Thompson at page 35 at line 8. She says, however, no individual was convicted of supply or transferring the firearm to the accused, and the rifle that was shown in court was returned to Tactical Security Services before judgment was delivered in this trial. Now, why does this matter? It matters because the forfeiture of firearms that are used in the commission of offenses regulated by the Criminal Procedure Act. My learned friend has already referred us to section 30 of the Criminal Procedure Act. But your leadership will discover that section 30 is actually inapplicable in the current circumstances, because it deals with disposal by police officials of articles after seizure. It doesn't deal with articles that are part and parcel of the criminal proceedings themselves. Similarly, section 31, which is another section that was relied upon by the legislature, refers to disposal of articles where no criminal proceedings are instituted, or where the article is not required for criminal proceedings. So we know in relation to the first requirement that criminal proceedings were instituted, and in relation to the second requirement, the firearm was required for criminal proceedings. So it also does not apply. What does apply are the two sections that were not referred to by my learned friend, which is section 34 of the Criminal Procedure Act. That section is headed Disposal of Articles After Commencement of Criminal Proceedings, which is where we are. Criminal proceedings have commenced. The article is a piece of the evidence that we use to prove the offense. It says the judge or judicial officer presiding at criminal proceedings shall, at the conclusion of such proceedings, but subject to the provisions of this act or any other law under which any matter shall or may be forfeited, make an order that any article referred to in section 33 be returned to the person from whom it was seized, if such person may lawfully possess such article. So it is up to your leadership to make an order that an item that was part and parcel of the commission of the offense, which was used in the criminal proceedings, may be returned. It is not up to the state. Why that is important is also section 35, which is another section that was not relied upon by the state. That deals with the forfeiture. So your leadership will know under section 34, you may order the item to be returned, but under section 35, you may order the item forfeited to the state as well. Because under section 35, subsection 1, it says a court which convicts an accused of any offense may, without notice to any person, declare any person, instrument, or other article by means whereof the offense in question was committed or which was used in the commission of an offense, or if such conviction is in respect of an offense referred to in Part 1 of Schedule 2, any vehicle, container, or any other article which was used for the purposes of or in connection with the commission of the offense in question, or for the conveyance or removal of the stolen property, and which was seized, and we know this firearm was seized under the provisions of this act, forfeited to the state. So what happened here is that the prosecutors on their own showing agreed with one of the accused persons to take the firearm before judgment was given. That raises profound questions of the propriety of the conduct of the prosecutors. They themselves admit that they sent an email, although they put a different slant to that email. The slant they put is that they said, if you are acquitted, you may come and collect the firearm. Whereas the provision in section 34 says the judge or the magistrate, whoever is residing, may make that. It raises profound questions, my lady, with the greatest of respect. The first is, how does the accused know that he must come and collect the firearm? But it also raises another question, which is, how did the state take this matter as serious if they were already making arrangements prior to judgment upon the return of the firearm? They say that there were emails that were exchanged, but those emails have not been produced. And that is in the context where a witness has given evidence. It is correct, as my Leonard points out, that the witness says, my source of the evidence, you see that in paragraph 5.1 of the report, my source is Mr. Malema. But if they have this email chain, you would expect that on the day the witness gives evidence, they put it to her. But they don't. And then they try to get that evidence introduced in argument, which your ladyship can just dismiss without more. So we submit, therefore, your ladyship, that there is a potential irregularity which flows from the non-compliance with Section 34 of the Criminal Procedure Act and the non-compliance potentially with Section 35 of the Criminal Procedure Act. But to say it also raises really profound questions about how this knowledge occurred prior to the delivery of the judgment. We leave it there and take it no further, but to say it does raise deeper questions that require interrogation. But it does show that even on the state's showing, they did not regard the offense to be serious. Why do you return the instrument of the commission of the offense prior to the delivery of the judgment? Why? So that's in relation to question 1, which is the return of the firearm. It says relevant to sentencing because it shows that the state did not treat this as serious, but it's also relevant to a larger question about the propriety of the conduct of the state. The second question I want to address then is to look closely at why does the state say Mr. Malema should go to jail? This is clearer because the main heads of argument are actually quite confusing about why they say that he should go to jail. It's clarified in the supplementary heads because there they identify 4 reasons, and I want to address each and every one of them now. The first one is this idea of premeditation, that the offense in question was premeditated. But it seems that they actually misread the evidence because the planning that Mr. Malema talks about, if you look at the supplementary heads of argument, the leadership will find this at paragraph 7 of the state's heads of argument. In the italicized portion, which has inverted commas at the bottom of the page, where Mr. Malema is quoted as having said everything was perfect and calculated and designed to be the way it was done. He is not talking about planning the commission of an offense, he's talking about planning the celebration, the celebratory event, even on what they have quoted here. So that's why it's important never to read words out of context. What they have done is that they've planted words in their heads of argument, and then they've imputed a meaning that those words were never designed to achieve. And we say, in addition to the distortion of what the actual evidence was, the evidence was not planning the offense, the evidence was about planning the event. That actually cases of planning and premeditation of a design. How are we going to rob a shop? How are we going to rob a bank? What they don't show is the spontaneity of a firearm being given to a person, one shot, which is on the evidence, and your ladyship, you'll see from our heads of argument. But the second conviction is about one bullet. It's one bullet, not the 22 bullets, one bullet. So ordinary cases of premeditation do not have that element, because what you find is that a group of criminals sit and they plot how to execute an offense. This is not where someone gets a firearm, they shoot, they retain the firearm, and that's the end of the story. So it's even inconsistent with a classic instance of premeditation. And bearing in mind, my lady, that the state says, if you look closely at what they say in paragraph 7, the most significant aggravating feature. In other words, they hinge their case on the premeditation. But if the basis of the premeditation is a misconstrual of the evidence, so leadership can discard that without more. So that's item 2. So we say your leadership can safely discard that because they've misconstrued the facts. And in any event, they overlook the fact that we're talking about one bullet. The second reason why they say Mr. Malema should go to prison is because they say it was 2 firearms. But we don't understand. They say 2 firearms, 22 live rounds, and 20,000 people within a community. We don't understand why they say that. If your leadership goes to our heads of argument, we start off by summarizing what the actual findings were, not what the state wishes the findings were, but what the courts said the findings were. And the important ones is 1.2, unlawful possession of ammunition in contravention with Section 90 of the Firearms Control Act, to wit. Now those words, to wit, usually mean in that. In other words, their point is to constrain the factual basis of the finding, not to expand it. A .223 Remington bullet, one bullet, without holding a license, permit, dealer's license, manufacturer's license, gunsmith's license, import or export, or in transit license or other authorization. 1.3, unlawful discharge. But that's the unlawful discharge of the one bullet that he was in possession of, referred to in the second conviction. So we have the same problem here, my lady, with the greatest of respect, that the findings are distorted. It's a narrative building. Yes, and my learned friend also points me to even the first finding is unlawful possession of a firearm, not the firearms, a firearm, one bullet. So we've got a problem here that when you look at the second reason why they say Mr. Malema should go to prison, there is a disjuncture between what the state says and what the court found. You can't do this. You can't send somebody to prison for reasons that the judge did not find him guilty of. So this is the problem now with item 2 firearms, 22 live rounds before 20,000 people. So in other words, the correct postulation is one bullet in a stadium of 20,000 people. One. That's the correct postulation. And then ask yourself, in those circumstances, should I send this man to prison? And it's so absurd that they say, don't only send him to prison, send him to prison for 15 years. It's like a game that they're playing. It's a game to inflame the passions of the public. Then the next reason why they say Mr. Malema should go to jail is, if you look at their supplementary heads, because he's a public leader and a role model. Now here, my lady, I sympathize with the state that we say, well, people that are holding positions of society should take responsibility and they should be good examples. But it's precisely the same reason that Ms. Thompson says you should look at Mr. Malema differently. And your leadership, I want to remind your leadership, when we were here during the evidence of Ms. Thompson, your leadership commented, and they said, what's so special about him? The state says he's special. When we now say today, treat him through the prism of Section 9, everyone is equal before the law. So in other words, my lady, what we have is that for the state that chops and changes its case, depending on what it wants to achieve at a particular point in time. Today, they are trying to expand the realm of penal activity as expansive as possible. And then they say, okay, look at the fact that he's a parliamentarian. But when the witness was here, they said, no, his parliamentary position is irrelevant. He must be treated like everybody else. But a court cannot follow that unprincipled approach. Your ladyship must apply Section 9 of the Constitution, which says everyone is equal before the law. We obviously take into account that Mr. Malema must bear responsibility as a leader in society. We don't run away from that. But it's precisely because of that factor that we say, if you actually look at the fact that he has been criminally charged, it's a public trial that he's been undergoing. The fact that since the day of the charge, there is not even an allegation that he has ever attempted anything to do with the possession of a firearm. The fact that even before he was charged with these offenses, there is not an inkling that Mr. Malema had the propensity to possess firearms or to discharge them openly and publicly, recklessly, as the state tries to argue today. And the fact that the public trial itself has a shaming effect on the public representative. It has a shaming effect on the public representative because already people are saying, oh, well, why should he not lose his seat in parliament? Why should he not lose his seat in the JSC? And the fact that, my ladies, the fourth part of it is that we are not asking for a no punishment. We are simply asking for a non-custodial punishment. And no one can sensibly say that other forms of punishment do not constitute punishment, which is the zero-sum argument posited by the state. There's only one punishment as far as that concerned, it's custodial. So what we say, my ladies, is that you have a range of penal options that would reflect the society's disapproval of, I would say, public misconduct by public representatives. And the custodial penalty, in fact, achieves the opposite. So we say that ultimately is a neutral fact that he's a public leader and a role model. The next one that they say you should actually send him to prison for is that he has no remorse. But they themselves say in Hewitt versus S, absence of remorse is not an aggravating factor. The state says that in paragraph 17 of their heads of argument. It's not an aggravating factor. But my lady, there is a fundamental legal problem with the argument. If an accused says after conviction, I disagree with the magistrate, I'm going to appeal because the magistrate has wrongly found me guilty. The state says, infer from that he's not remorseful. It's absurd because even under Section 35 of the Constitution, he has a right to an appeal. And the right to an appeal is based on a view held by an accused, wrongly or what, that the magistrate is wrong. You cannot say, I am going to punish this accused because he articulated a view that I'm wrong. That is just an abuse of judicial authority. So he is entitled to say, I respectfully think that the judge got it wrong, and I'm going to appeal. The judges on appeal may say to him, Mr. Malema, it is you who's wrong, and not the judge. But in expressing a penalty, a judge cannot say, I'm going to punish you more because you've said it's absence of remorse just because you say, I do not agree. And I want to take this point further about the absence of remorse. They say, Mr. Malema has said these proceedings are an abuse of resources and the prosecutors are incompetent. That's what they say in their heads of argument. But my lady, if the prosecutor takes personal an accusation that they are incompetent, you know what happens? They violate Section 179 of the Constitution, which says that they must prosecute without fear, without favor, without prejudice. In other words, they must be prepared to accept the accusations and the criticisms from accused persons. They must not say, this accused person said that we are incompetent and therefore he must be punished more. Because that is not how the law works. The law works on a dispassionate basis. Whether someone has a loud mouth or that doesn't have a loud mouth, they must still be treated in accordance with the law. So we say that there is a deeper problem with this idea that because he said they were incompetent, therefore he must be punished, because it's not retributive, which is fine for sentencing, but it's vindictive, which is in conflict with the Constitution. So we say your leadership cannot give an order that would be in violation of Section 179 of the Constitution. Then they say, this is now paragraph 18, where in B they said, it described the proceedings as an abuse of the NPA resources and an incompetent prosecutor, and that AfriForum was to be blamed. Again, we all know the history of this case, my lady. We don't have to repeat it. It is AfriForum that has been behind the prosecution of Mr. Malema.
On which ones? Supplementary or the first one? 18B.
So there they say, Mr. Malema complains of the political vendetta by AfriForum. That's the point I'm addressing. Leadership doesn't want me to refer to AfriForum, that's fine.
No. Sorry, Advocate Nkukaitobi. I'm just quickly reading what you are referring me to before saying that I don't want you to say it. Let me just read the paragraph
Thank
quickly.
you.
Okay. Advocate Nkukaitobi, I've got that. I hear you. This is what the narrative of your client's evidence was during his evidence in chief and cross-examination, which the state is quoting here, according to my understanding. But you may proceed. I'm noting what you are saying.
It is the state that says that Mr. Malema lacks remorse because he has blamed AfriForum. I'm simply explaining.
And the Holy Spirit, including
I'm not dealing with the Holy Spirit, I'm dealing with AfriForum.
Please leave. I've spoken, so I was very clear that there'll be no choice. So I don't know how we are going to approach this. It's distracting to counsel for the accused. It's distracting to the state and to the court. And I do not need your approval of yes and no, because I'm independent. I don't mind yes or no at all. So do you leave or what? Because I'm not going to tolerate it. So there's a whoever wants to comment, please leave. Whoever is commenting now, please leave. And from now on, I will leave that in the hands of SAPS. Whoever comments or speaks, ask them to leave, please, because I'm concentrating on what counsel is saying to court. Sorry for that.
Let me just make one sentence on AfriForum, because I think that's what is increasing the temperature inside.
I'm listening.
Mr. Malema is entitled to regard AfriForum as a political adversary and to criticize it for an unfair prosecution, because he believes that they are behind the prosecution. What you cannot do, you cannot take that political statement by Mr. Malema and take it to account in sentence.
I hear you fully, yes.
Thank you, madam. Then they are also complaining that he has complained of racism. Why is the state complaining that Mr. Malema is complaining of racism when he's a victim of racism? It makes no sense to me at all.
Okay, I'm not going to respond, but I'm listening, yes.
No, I'm not asking you to respond. It's a rhetorical question. Is why would the NPA complain that Mr. Malema is saying this prosecution is part of a racist campaign against him? Why would they have an issue with that? And why would your leadership be required to put that in your judgment, in sentencing? Now, the last one is the Holy Spirit. Nothing is said about that. Then C is showing no insight to the danger of 20,000 people. But if you look at closely, it is precisely the same point as Roman figure 2. Nothing is added by putting it here. Then D, he has sought throughout to conflate the rule of law with political persecution, undermining public confidence in the administration of justice. Now, it's unclear what are the facts on which they rely here. Why do they accuse him of undermining public confidence in the administration of justice? What did he actually do? Because, my lady, people that undermine confidence in the administration of justice, you know what they do? They don't come to court at all. They shout at the court from outside, and then they are ultimately found guilty of contempt of court for not showing up. Mr. Malema has been exemplary throughout the trial. He has been truly exemplary. If he's told come on the 9th to the 20th, he's here on the 9th to the 20th. Come at 8:30, he's here at 8:30. He has never once missed a beat. When he had to give evidence, obviously his personality came through, as you heard from the witness, who said he does have a combative style of speaking. But having a combative style of speaking should not be conflated with disrespect of the judicial process. So we would submit to your ladyship that you cannot take this factor into account. There's just no evidence that Mr. Malema ever acted in a manner that shows disrespect to the proper administration of justice. This is particularly so when the prosecutors are not confident enough to pinpoint the specific evidence on which they rely for saying he has undermined the administration of justice. And then, my lady, here's the point I was making in paragraph 19. Critically, the probation officer, Ms. Thompson, herself acknowledged that the accused continues to assert his innocence. So this is the point, my lady. After conviction, the accused says, I'm innocent. Now the state says, take that into account against the accused. He will say he's innocent until the constitutional court says you are guilty, at which point he will then accept that perhaps I'm the only one who believes I'm innocent and everyone else thinks I'm guilty. But the mere fact that at this stage he is asserting his innocence is not a factor that counts against him. But if you did that, you then violate Section 35 of the Constitution that gives you the right to appeal. The last point, my lady, is to correct some legal misconceptions. Your ladyship has been given this case, Janssen versus the state, by Fansei TJP. My lady, this case is unhelpful to you. This case is about someone with previous convictions. It is a case where minimum sentencing legislation applies. And it is a case, if you look at paragraph 2 of the judgment, where it says the appellant produced the firearm, Robbenheimer ran away and he heard the sounds of gunshots. The appellant was known to him as being a member of a gang called the Fat Cats. It's the case of gangsters. It's not a case of a politician in a temporary lapse shoots a firearm to the sky. This is a case of proper gangsters. There's absolutely no basis why the prosecutor says you should read this judgment. It will help you, because it will not help you. Then, my lady, you have a collection of cases. And again, this is another misconception. We've cited, and I will ask your ladyship when you retire to have regard to these judgments. In paragraph 31 of our head of argument, we've done precisely what the state says we didn't do, which is to separate cases of possession from cases of discharge, and to look at the patterns of sentencing for possession versus the patterns of sentencing for discharge. What we find at paragraph 31, and this is all set out very usefully in the judgment of Cluster J, S versus Matigane, where he refers to, I think at that point, all sentences that he was aware of on possession. So, you see, S versus Malema, the sentence that it was an automatic firearm, not semi-automatic, automatic. the sentence was, there was a direct imprisonment. On appeal, it was altered to 2,000 hours of periodic imprisonment. As versus Zondi, where there was a conviction and a direct imprisonment, but converted to a fine of 2,000 rands or 18 months imprisonment. And then the last one that would be relevant for our purposes is S versus Limo, which is the last of those cases. Initially 18 months, and then ultimately converted to 6 months, fully suspended. Those are possession cases, possession. And then we then deal with discharge cases, which we start dealing with at paragraph 35. S versus Fayun, S versus Pistorius, Munsami and Anaga, and the Bada versus S, paragraph 41. Yes, 4 judgments. What the pattern appears to be, my lady, is that almost invariably, in discharge cases where there's no harm, no direct imprisonment is ever ordered. Pure discharge. No direct imprisonment is ever ordered. All of the cases we found, discharge the firearm in the sky. I mean, Julius' case was actually a paradigmatic one because it's actually in an enclosed room. It's like here in the court, place is full of people, and then Oscar shoots the firearm. Scotches firearm, someone else shoots it to the roof, and then they say 3 years fully suspended. Don't go to prison. So the pattern on discharges where no harm is an issue is non-custodial as a default position. For possession, the pattern is mixed. I accept what my learned friend says that there are cases we find of 7 years. But virtually every case we've looked at that they have cited always involves that this one we've looked at gangsters or some sort of other offense that is the possession is part and parcel thereof. Not one case involves an instance, which is what we describe as a fleeting possession. Somebody comes in, take this firearm, shoot it inside the crowd, bring it back to me. Never found a case like that. So it is not correct for my learned friends to ultimately come to the conclusion that the pattern of sentencing in possession cases reflects custodial sentences of between 7 and 15 years. That's just not part and parcel of the law. So, my lady, what you really have a wide canvas. A wide canvas that starts from fully suspended, mixed suspended plus fine, or fines. Then it stretches all the way to 15 years. That's the true state of the law. And we have shown in this case the unique facts that were pleaded by Ms. Thompson. And then a friend can complain about Ms. Thompson's bias, etc., etc. But the fact of the matter is there's only one witness on sentences, one witness. The state could have controverted that by bringing their own witness. They never did so. So, my lady, we come back then to the beginning. We ask for a non-custodial sentence. But the nature of that non-custodial sentence is in your ladyship discussion. What we simply say is that it will be contrary to the law. Not because we like Mr. Malema or anything. It will be contrary to the law to send him to prison. Thank you.
Thank you, Advocate Nkosi. Thank you. There's no provision for you to reply, Advocate Caesar. This is it. The defense, am I going to indulge him? It's not procedure. He's trying, he wants to rise, so you may outvote him.
It's supplementary argument, and even after his arguments, he has an extra point.
Okay, the extra point I disregard, but with the rest, we stick to procedure. Is it a new point?
There's no need to address anything.
What you want is not raise the point, but on what is the basis of you wanting to do so that I can listen to, and then I can tell you yes or no.
No, you was just going to advise council to read section 30
I-
and 34.
No, okay. That is a no. All right. Thank you, Advocate Caesar. All right. So that is us for the day.
But then, since no one is speaking to your leadership when you ask them, that is it.
Mm.
The one thing we agree with the state on is that we need to get finished with this.
Yes.
If your leadership is ready with a judgment this afternoon, we would appreciate it.
Advocate Nkukai Toby, let me be very clear and maybe indulge not in a because I'm not ready. The aspect of sentence today is still to be decided. Let me explain so that everyone, and I'm sure I do not have to explain. You are all senior officials and very much aware of what I'm about to say. What you read on paper materializes when it's said loud in court. The impact, the tone is not reflected on paper. It's heard and experienced when you are in court. So the actual sentence, yes, must be determined. Having done the groundwork and the summaries, that has all been done. But to say proceed when I've just heard a whole lot of additional information, I have to structure and
I have absolutely no problem. Your leadership is adjourning us to a date to be advised.
No, we've got 2 days and I intend to do our utmost to reach our end goal. I just don't want to say and commit after I've explained why, and you all know when you read and when someone says it's a different, totally different impact when you hear and when you read in your office. It's then you go back, as you say, you retire, not yet though, and you combine the two. So that is what I intend doing this afternoon. So we can, sorry, I see you're keeping you on your feet, but you are free to take a seat. I can go to the extent of, just so that we don't waste time at 9 a.m., to place the counts and the penalty clauses and the minimum, the formalities on record, because that's not something I have to prepare. It's a fact before all of us, but I need to place it on record. I can do that. Or we can say 9 a.m., but I'm not going to go beyond that. So
Lady, we are just in your hands.
I think it's inconvenient for everyone for me to come back. I will ask you, and maybe you can, Advocate Otis, Caesar, your client. I'm thinking of all the media stations and such to return for me to read out a formality which is known to all, or come back at 9 a.m. But I intend, as I say, not to go beyond and for us to reach our goal as planned.
At 9 a.m. tomorrow.
Then your word is my command. Agree, Advocate Caesar? All defense? All right. Mr. Malema, just a minute, please, gentlemen. The court is not adjourned yet. We are still busy. For the reasons I've mentioned then, and for us to, or for the court to proceed or commence with sentence, and hoping that we will reach the finality of this matter tomorrow for anything that may follow. Tomorrow, I would assume it's the same venue, but I'm also directed by the management. I assume it's the same, 8:30, for us to start at 9 a.m. I'm sure the same venue, which is High Court venue. Okay. Thank you. Court will adjourn. Stop.